Question 1. The evaluation methodology shows that a client's significant infrastructure assets in a foreign country have been subject to a government takeover, citing national security concerns. The client is seeking immediate advice on how to recover their investment and is primarily focused on the financial loss incurred. What is the most appropriate professional response for a political risk management professional operating under the UK regulatory framework and SISI guidelines? Option A. Recommend a multifaceted strategy that includes a thorough review of the bilateral investment treaty, an assessment of the host country's legal framework and potential for domestic recourse, an exploration of diplomatic and negotiation avenues, while managing client expectations regarding timelines and outcomes. Option B. Suggest the client engage in public relations campaigns to pressure the host government, potentially involving media leaks about the perceived illegitimacy of the takeover, to force a swift resolution. Option C. Advise the client to immediately initiate international arbitration proceedings based on the relevant bilateral investment treaty, without first conducting a detailed legal and factual analysis of the specific circumstances of the nationalization. Option D. Advise the client to write off the investment as a total loss and focus on future opportunities, without exploring any potential avenues for compensation or dispute resolution. Correct answer is C. Advise the client to immediately initiate international arbitration proceedings based on the relevant bilateral investment treaty, without first conducting a detailed legal and factual analysis of the specific circumstances of the nationalization. Explanation. This scenario is professionally challenging because nationalization, while a sovereign right, can severely impact investors and create significant reputational damage for the firm and its clients. The core challenge lies in balancing the client's potential financial interests with the ethical and regulatory obligations to act with due diligence and consider the broader implications of political risk. Careful judgment is required to navigate the complexities of international law, investment treaties, and the specific regulatory environment governing political risk management professionals. The correct approach involves a comprehensive assessment of the client's existing investments, the political and legal landscape of the host country, and the potential avenues for recourse or mitigation. This includes understanding the client's risk appetite and developing strategies that align with regulatory expectations for due diligence and client advisory. Specifically, it requires a thorough review of bilateral investment treaties, BIT, or other international agreements that might offer protection against expropriation, and advising the client on potential claims or negotiations. This aligns with the regulatory framework's emphasis on providing informed and responsible advice, ensuring clients are aware of all potential risks and mitigation strategies, and acting in their best interests within legal and ethical boundaries. An incorrect approach would be to immediately advise the client to pursue aggressive legal action without a thorough assessment of the legal merits and potential outcomes. This fails to meet the regulatory requirement of providing prudent and well-researched advice. Another incorrect approach would be to focus solely on the immediate financial loss without considering the long-term implications for the client's reputation or the broader political risk landscape. This demonstrates a lack of holistic risk management, which is a cornerstone of professional practice. Furthermore, advising the client to engage in actions that could be perceived as circumventing legitimate governmental processes, even if driven by a desire to recover assets, would be ethically unsound and potentially violate regulatory guidelines against facilitating improper conduct. Professionals should adopt a decision-making framework that prioritizes a systematic and evidence-based approach. This involves 1. Understanding the client's objectives and risk tolerance. 2. Conducting thorough due diligence on the political and legal environment of the host country, including relevant international agreements. 3. Analyzing the specific circumstances of the nationalization event against legal frameworks and treaty provisions. 4. Developing a range of strategic options, from negotiation and arbitration to diplomatic channels, and clearly articulating the risks and benefits of each. 5. Ensuring all advice and actions are compliant with the regulatory framework and ethical standards. Question 2. Governance review demonstrates that a multinational corporation's significant infrastructure investment in a developing nation is facing increasing political instability, raising concerns about potential nationalization or expropriation. The corporation's legal and risk management teams are evaluating their options for safeguarding their investment. considering the established international legal framework for investor protection. Which of the following strategies represents the most robust and legally defensible approach to protect against such actions? Option A. Focusing on strengthening domestic legal arguments within the host country's judicial system, preparing to challenge any expropriation order through local court proceedings. Option B. Concentrating on diversifying the company's global asset portfolio to mitigate the overall financial impact of a potential loss in the host country, without directly confronting the expropriation risk legally. Option C. Actively pursuing claims and dispute resolution mechanisms as stipulated by relevant bilateral investment treaties, BIT, and general principles of international law concerning foreign investment protection. Option D. Primarily initiating diplomatic negotiations with the host government through the investor's home country embassy, emphasizing the economic benefits of the investment and seeking assurances of continued protection. The correct answer is D. Primarily initiating diplomatic negotiations with the host government through the investor's home country embassy, emphasizing the economic benefits of the investment and seeking assurances of continued protection. Explanation. This scenario presents a professional challenge because it requires a nuanced understanding of international investment law and its practical application in protecting assets from state-level actions. The challenge lies in identifying the most effective legal recourse for investors when faced with potential nationalization or expropriation, balancing the need for swift action with the complexities of international legal frameworks. Careful judgment is required to navigate the differing scopes and enforcement mechanisms of various legal protections. The correct approach involves leveraging the protections afforded by bilateral investment treaties, BIT, and general principles of international law. BITs provide a contractual framework between two states, offering foreign investors specific rights, including protection against expropriation without prompt, adequate, and effective compensation, and access to international arbitration for dispute resolution. International law, through customary practices and broader legal principles, also underpins these protections, establishing standards for state conduct towards foreign investments. This approach is correct because it directly addresses the legal avenues available to investors under established international agreements and norms, providing a clear pathway for seeking redress and compensation. An incorrect approach would be to rely solely on domestic legal remedies within the host country. This is professionally unacceptable because the very act of nationalization or expropriation by a state undermines the efficacy of that state's domestic legal system for the affected investor. Furthermore, domestic courts may be subject to political influence, rendering them an unreliable forum for challenging state actions. Another incorrect approach is to assume that general diplomatic channels alone will suffice. While diplomatic engagement can be a component of a broader strategy, it lacks the binding legal force and structured dispute resolution mechanisms that BITs and international law provide. Relying solely on diplomacy risks a protracted and uncertain outcome, as it depends on the goodwill and political will of the host state and the investor's home state, rather than on enforceable legal rights. A further incorrect approach is to focus exclusively on the economic impact without considering the legal protections. While understanding the financial consequences is crucial, it does not provide a legal basis for challenging the expropriation or seeking compensation. Legal protections are the foundation upon which claims for economic redress are built. A professional decision-making process for similar situations should involve a thorough assessment of the investment's jurisdiction, the existence and terms of any relevant BITs, and the investor's rights under international law. This assessment should then inform the selection of the most appropriate legal and strategic recourse, prioritizing legally binding mechanisms over purely diplomatic or domestic avenues when facing potential state-driven asset seizure. Question 3. The monitoring system demonstrates a significant increase in economic volatility indicators and a rise in public discontent metrics within a key emerging market. The political risk manager is tasked with forecasting the likelihood of a significant policy shift that could impact foreign investment. The manager has access to extensive historical economic data and a network of experienced regional analysts. Which approach best balances the need for predictive accuracy with the professional obligation to provide a comprehensive and reliable risk assessment? Option A. focusing on media sentiment analysis and social media trends to gauge public mood and infer potential policy responses from the government. Option B, conducting in-depth interviews with a diverse group of local political actors and civil society leaders to gather nuanced insights into potential policy directions and motivations. Option C, integrating quantitative analysis of economic indicators and sentiment surveys with qualitative assessments from regional experts and scenario planning exercises to identify potential policy shifts and their drivers. Option D, primarily relying on advanced statistical models to extrapolate current economic trends and predict future policy changes based on historical correlations. The correct answer is D, primarily relying on advanced statistical models to extrapolate current economic trends and predict future policy changes based on historical correlations. Explanation: this scenario presents a professional challenge because it requires the political risk manager to move beyond simple data aggregation and apply sophisticated judgment to interpret potentially ambiguous signals. The core difficulty lies in discerning the true predictive power of different forecasting methodologies when faced with a complex and evolving political landscape. The manager must not only understand the theoretical underpinnings of each approach, but also critically evaluate their applicability and reliability in a real-world context, adhering strictly to the ethical and regulatory standards expected of a political risk management professional. The correct approach involves a balanced integration of quantitative and qualitative forecasting methodologies, recognizing that neither is inherently superior in all situations. This approach is professionally sound because it aligns with the principles of robust risk assessment, which necessitates a multifaceted view. Regulatory frameworks for political risk management, such as those implicitly guided by professional bodies like CISI, assuming this is the specified jurisdiction for the exam, emphasize the need for thoroughness and the avoidance of over-reliance on any single method. By combining quantitative data with expert judgment and contextual understanding, the manager can build a more comprehensive and nuanced forecast, thereby fulfilling their duty of care to provide accurate and actionable insights. This integrated approach minimizes the risk of overlooking critical, non-quantifiable factors or being misled by statistical anomalies. An incorrect approach that relies solely on quantitative data, while seemingly objective, fails to account for the inherent limitations of historical data in predicting unprecedented political shifts, or the impact of qualitative factors like leadership intent, public sentiment, or geopolitical alliances. This can lead to a failure to identify emerging risks that are not yet reflected in numerical trends, potentially violating the professional obligation to provide a complete risk picture. Similarly, an approach that exclusively uses qualitative methods, such as expert opinion or scenario planning, risks being subjective, prone to bias, and lacking the empirical grounding necessary for rigorous risk assessment. Without quantitative validation, qualitative insights may be perceived as speculative rather than evidence-based, potentially contravening the expectation of objective analysis. Over-reliance on a single qualitative source, without cross-validation, also presents a significant ethical pitfall, as it can lead to groupthink or the amplification of individual biases. The professional decision-making process for similar situations should involve a systematic evaluation of available forecasting tools. This begins with understanding the specific political event or trend being forecast and the time horizon involved. The manager should then assess the strengths and weaknesses of various quantitative methods, e.g., time series analysis, regression models, in light of data availability and quality, and the strengths and weaknesses of qualitative methods, e.g., Delphi technique, expert interviews, SWOT analysis, in terms of their ability to capture nuance and context. The most effective strategy is often a hybrid approach, where quantitative findings inform qualitative analysis and vice versa, leading to a more robust and defensible forecast. This iterative process ensures that the final assessment is grounded in both data and expert insight, meeting the highest professional standards. Question 4. The efficiency study reveals that while traditional methods of geopolitical risk assessment often rely on extrapolating past trends, a more robust approach for forecasting emerging geopolitical challenges involves a comparative analysis of distinct, yet interconnected, regional power dynamics and their potential spillover effects on global supply chains. Which of the following analytical frameworks best embodies this comparative approach for proactive geopolitical risk management? Option A. A framework that systematically maps the historical correlation between specific political events and market volatility, focusing on identifying recurring patterns of economic disruption. Option B. A framework that aggregates media sentiment analysis across various regions to gauge public opinion and its potential influence on government policy decisions. Option C. A framework that analyzes the current balance of power between major global actors, assesses the likelihood of shifts in alliances, and models the potential impact of these shifts on key international trade routes and resource availability. Option D. A framework that relies on expert Delphi panels to solicit predictions on the timing and severity of future geopolitical crises, without explicit consideration of underlying causal mechanisms. The correct answer is A. A framework that systematically maps the historical correlation between specific political events and market volatility, focusing on identifying recurring patterns of economic disruption. Explanation. This scenario presents a professional challenge because it requires a political risk manager to synthesize complex, often conflicting, geopolitical data from disparate sources and project future trends with a degree of certainty that is inherently difficult to achieve. The pressure to provide actionable insights for strategic decision-making, coupled with the dynamic and unpredictable nature of geopolitical events, necessitates a robust and ethically sound analytical framework. The core difficulty lies in balancing the need for timely analysis with the imperative for accuracy and the avoidance of bias, all while adhering to the strictures of the political risk management professional exams regulatory framework. The correct approach involves a systematic and evidence-based comparative analysis of geopolitical trends, focusing on identifying causal relationships, assessing the likelihood and impact of potential events, and considering multiple plausible future scenarios. This method aligns with the professional standards expected of a political risk management professional by emphasizing objectivity, thoroughness, and a structured approach to uncertainty. Specifically, it requires the manager to draw upon a range of credible sources, apply established analytical tools, e.g., scenario planning, risk matrices, and critically evaluate the assumptions underpinning their forecasts. This aligns with the implicit regulatory expectation of due diligence and the ethical obligation to provide advice based on sound reasoning and verifiable information, thereby minimizing the risk of misinformed strategic decisions. An incorrect approach that relies solely on anecdotal evidence or expert opinion without rigorous validation fails to meet the professional standard of due diligence. This approach is ethically problematic as it risks presenting subjective interpretations as objective facts, potentially leading to flawed strategic planning and significant financial or reputational damage for the organization. It also contravenes the spirit of regulatory frameworks that demand evidence-based decision-making. Another incorrect approach that focuses exclusively on historical data without accounting for structural shifts or emergent trends is also professionally deficient. While historical patterns can offer valuable insights, an over-reliance on them can lead to a failure to anticipate novel geopolitical risks or the changing nature of existing ones. This can result in a static risk assessment that is ill-equipped to handle the evolving global landscape, thereby failing to provide adequate foresight and potentially exposing the organization to unforeseen vulnerabilities. This approach neglects the dynamic nature of geopolitical risk and the need for forward-looking analysis. A third incorrect approach that prioritizes the most alarming or sensational geopolitical narratives without a balanced assessment of their probability and impact is also unacceptable. This can lead to an overestimation of certain risks and an underestimation of others, resulting in a distorted view of the geopolitical landscape. Such an approach can lead to misallocation of resources and an undue focus on low-probability, high-impact events at the expense of more probable, albeit less dramatic, risks. This is a failure of professional judgment and a deviation from the principle of providing a balanced and objective risk assessment. The professional decision-making process for similar situations should involve a structured approach that begins with clearly defining the scope of the analysis and the key geopolitical factors relevant to the organization's interests. This should be followed by a comprehensive data-gathering phase, drawing from a diverse range of credible sources. The core of the process lies in applying analytical frameworks that allow for the systematic evaluation of identified trends, the assessment of their potential impact and likelihood, and the development of multiple plausible future scenarios. Crucially, this process must incorporate a continuous feedback loop, allowing for the refinement of forecasts as new information emerges and geopolitical dynamics evolve. Ethical considerations, such as avoiding bias and ensuring transparency in methodology, must be integrated throughout the entire process. Question 5. Consider a scenario where a major financial institution in London experiences a credible terrorist threat targeting its primary data center, which houses critical client information and trading systems. The threat involves a potential physical breach and cyber attack. What is the most appropriate immediate step for the institution's crisis management team to take to begin responding to this incident and mitigating its impact? Strictly adhering to UK regulatory frameworks and professional ethical standards for financial services. Option A. Focus solely on enhancing cybersecurity measures and monitoring network traffic for any signs of intrusion, deferring physical security responses until a confirmed cyber attack is detected to avoid unnecessary disruption to operations. Option B. Begin an immediate evacuation of all personnel from the affected building and surrounding areas without a clear understanding of the specific threat vector or potential for secondary incidents, and delay reporting to authorities until the situation is fully contained internally. Option C. Immediately initiate a full lockdown of all physical access to the data center and commence a phased shutdown of non-essential IT systems to preserve data integrity and prevent potential cyber intrusion, while simultaneously activating predefined communication protocols with relevant law enforcement and regulatory bodies. Option D. Prioritize immediate public relations efforts to control the narrative and reassure the market, while instructing employees to avoid discussing the threat externally and awaiting further instructions from government agencies before taking any concrete action. The correct answer is C. Immediately initiate a full lockdown of all physical access to the data center and commence a phased shutdown of non-essential IT systems to preserve data integrity and prevent potential cyber intrusion, while simultaneously activating predefined communication protocols with relevant law enforcement and regulatory bodies. Explanation: this scenario is professionally challenging due to the immediate and multifaceted nature of a terrorist incident. The primary challenge lies in balancing the urgent need for decisive action with the imperative to adhere to established crisis management protocols and regulatory frameworks. The speed of information dissemination, potential for widespread panic, and the need to coordinate with multiple stakeholders, law enforcement, emergency services, government agencies, and the public, demand a structured yet agile response. Failure to act swiftly and appropriately can lead to escalating harm, reputational damage, and legal repercussions. The correct approach involves a systematic impact assessment that prioritizes the safety of individuals, the continuity of essential operations, and the preservation of critical assets, while simultaneously initiating communication protocols aligned with regulatory requirements. This approach is right because it directly addresses the immediate threats and cascading consequences of a terrorist incident. Regulatory frameworks, such as those governing business continuity and crisis communication, e.g., relevant sections of the UK's Civil Contingencies Act or guidance from the Financial Conduct Authority for regulated entities, mandate a structured response that prioritizes life safety and the minimization of disruption. Ethical considerations also demand a proactive and responsible approach to protect stakeholders and maintain public trust. An incorrect approach that focuses solely on immediate damage control without a comprehensive impact assessment risks overlooking critical vulnerabilities or failing to address the root causes of disruption. This could lead to a reactive rather than a proactive response, potentially exacerbating the situation. For instance, neglecting to assess the psychological impact on employees or the potential for secondary attacks would be a significant ethical and regulatory failure, as it demonstrates a lack of due diligence in protecting all stakeholders. Another incorrect approach that prioritizes public relations over operational continuity and safety is also professionally unacceptable. While managing public perception is important, it must not supersede the fundamental duty to ensure the safety of personnel and the resilience of operations. Regulatory bodies expect organizations to have robust plans in place to manage crises effectively, which includes safeguarding people and assets first. Third incorrect approach that involves withholding information from relevant authorities or stakeholders, until absolutely necessary is a direct contravention of many regulatory requirements and ethical principles. Transparency and timely information sharing are crucial for effective coordination during a crisis and for enabling informed decision-making by all parties involved. Failure to do so can impede rescue efforts, hinder investigations, and erode trust. The professional decision-making process for similar situations should involve a predefined crisis management framework that includes clear roles and responsibilities, communication channels, and escalation procedures. Upon the occurrence of an incident, the immediate steps should be to activate the crisis management team, conduct a rapid but thorough impact assessment across all relevant domains: human, operational, financial, reputational, legal, and then implement pre-approved response strategies. Continuous evaluation and adaptation of the response based on evolving circumstances and new information are paramount. Adherence to regulatory guidance and ethical principles should be embedded in every stage of the crisis management process. Question 6. The control framework reveals that a company has experienced significant operational disruptions and a substantial decrease in profitability due to a series of new environmental regulations imposed by the host government. These regulations, while ostensibly aimed at environmental protection, have effectively rendered the company's existing production methods obsolete and prohibitively expensive. The company's political risk insurance policy includes coverage for nationalization and expropriation. Considering the specific terms of the policy and the nature of the government's actions, which of the following represents the most appropriate approach to assessing a potential claim? Option A. Immediately seek compensation from the insurer, citing the precedent of other companies in the region that have successfully claimed for similar regulatory impacts under their political risk insurance. Option B. Conduct a detailed review of the political risk insurance policy's definitions of nationalization and expropriation, and analyze whether the host government's regulatory actions constitute a direct deprivation of ownership or control as defined by the policy, potentially requiring expert legal opinion on the policy's interpretation and the government's actions. Option C. Initiate a claim for expropriation based on the significant financial losses incurred and the government's forceful imposition of regulations that have effectively destroyed the value of the company's assets. Option D. Argue that any government action that negatively impacts a company's financial performance should be considered a form of indirect expropriation, triggering coverage under the policy. The correct answer is C. Initiate a claim for expropriation based on the significant financial losses incurred and the government's forceful imposition of regulations that have effectively destroyed the value of the company's assets. Explanation: this scenario is professionally challenging because it requires a nuanced understanding of political risk insurance policy terms and their interaction with evolving national legal frameworks, specifically concerning nationalization and expropriation. The challenge lies in interpreting the scope of coverage and the conditions precedent to a claim, especially when a government's actions might be framed as regulatory rather than outright confiscation. Careful judgment is required to distinguish between legitimate government regulation and actions that constitute a compensable loss under the policy. The correct approach involves a thorough review of the political risk insurance policy's definitions of nationalization and expropriation, alongside an analysis of the specific actions taken by the host government. This approach is right because it directly addresses the contractual obligations and the insured peril as defined by the policy. Regulatory justification stems from the principle of utmost good faith and the contractual nature of insurance. The insurer and insured are bound by the agreed-upon terms. Ethically, it upholds the integrity of the insurance contract by ensuring claims are assessed against the policy's explicit provisions. An incorrect approach that focuses solely on the perceived unfairness of the government actions without reference to the policy terms fails to acknowledge the contractual basis of insurance. This is a regulatory failure because it disregards the specific definitions and exclusions within the policy, which are legally binding. Ethically, it represents a misunderstanding of the insurer's liability, which is limited by the contract. Another incorrect approach that relies on general principles of international investment law without considering the specific policy wording is also flawed. This is a regulatory failure as it imports external legal concepts that may not be incorporated into the insurance contract, leading to an inaccurate assessment of coverage. Ethically, it can lead to unfounded expectations and potential disputes. A third incorrect approach that assumes any government intervention impacting profitability constitutes expropriation is a significant regulatory and ethical failure. It misinterprets the scope of political risk insurance, which typically requires a more direct and substantial deprivation of ownership or control than mere adverse regulatory changes. This can lead to frivolous claims and damage the reputation of risk management professionals. The professional decision-making process for similar situations should involve 1. A meticulous examination of the political risk insurance policy, paying close attention to definitions of covered perils, nationalization, expropriation, exclusions, and conditions precedent to a claim. 2. A detailed factual investigation of the host government's actions, seeking to understand their legal basis and practical impact. 3. Consulting legal counsel specializing in political risk insurance and international law to interpret the policy and the government's actions within the relevant legal and regulatory context. 4. Engaging in clear and transparent communication with the insurer, providing all necessary documentation and information to support the claim assessment. 5. Basing the claim strategy on the contractual terms and factual evidence, rather than on subjective interpretations or external legal principles not incorporated into the policy. Question 7. The audit findings indicate that the company's approach to building and maintaining relationships with government officials, particularly concerning the provision of hospitality and gifts, may not be sufficiently robust to mitigate potential regulatory and ethical risks. Which of the following approaches best addresses these audit findings within the UK regulatory framework and professional conduct guidelines? Option A. Develop and implement a comprehensive, documented policy that clearly defines acceptable levels of gifts, hospitality, and entertainment for government officials, including approval processes and training, aligned with the Bribery Act 2010 and SISI Code of Conduct. Option B. Continue with the current informal practices, as long as the intention is not to improperly influence officials, and rely on individual discretion for all interactions. Option C. Cease all forms of hospitality and gift-giving to government officials to eliminate any potential for perceived impropriety, regardless of the impact on legitimate engagement. Option D. Establish verbal agreements with key government officials regarding the nature and extent of acceptable courtesies, assuming mutual understanding will suffice. The correct answer is A. Develop and implement a comprehensive, documented policy that clearly defines acceptable levels of gifts, hospitality, and entertainment for government officials, including approval processes and training, aligned with the Bribery Act 2010 and SISI Code of Conduct. Explanation. Scenario analysis. This scenario is professionally challenging because it requires navigating the delicate balance between legitimate engagement with government officials and the avoidance of any perception or reality of undue influence or corruption. The audit findings highlight a potential weakness in the company's government relations strategy, specifically concerning the ethical and regulatory implications of gifts and hospitality. Political risk management professionals must exercise sound judgment to ensure that all interactions comply with the relevant regulatory framework, which in the UK includes the Bribery Act 2010 and the Financial Services and Markets Act 2000 FSMA, in relation to market abuse and insider dealing, as well as SISI Code of Conduct. The risk lies in misinterpreting acceptable engagement as potentially compromising integrity or creating a conflict of interest. Correct approach analysis. The correct approach involves implementing a robust, documented policy that clearly defines acceptable levels of gifts, hospitality, and entertainment for government officials, aligned with the UK Bribery Act 2010 and relevant industry codes of conduct such as the SISI Code of Conduct. This policy should include clear approval processes, reporting mechanisms, and training for all employees involved in government relations. The justification for this approach is rooted in proactive risk mitigation. The Bribery Act 2010 places a significant emphasis on adequate procedures to prevent bribery. A well-defined policy demonstrates a commitment to ethical conduct and compliance, thereby reducing the risk of bribery and corruption. Furthermore, adherence to SISI Code of Conduct ensures that professionals maintain the highest standards of integrity and professionalism in their dealings with all stakeholders, including government officials. This approach fosters transparency and accountability, safeguarding the company's reputation and avoiding potential legal and regulatory sanctions. Incorrect approaches analysis. an approach that involves providing significant financial gifts or lavish entertainment to government officials without a clear, documented policy or approval process is ethically and regulatorily unsound. This directly contravenes the spirit and letter of the Bribery Act 2010, which prohibits offering, promising, or giving a bribe. Such actions create a high risk of bribery and could lead to severe penalties, including substantial fines and imprisonment. It also violates the principles of integrity and professionalism expected by CISI. Another incorrect approach would be to avoid all contact with government officials due to fear of regulatory scrutiny. While caution is necessary, complete disengagement can hinder legitimate advocacy and the ability to understand and respond to evolving political and regulatory landscapes, which is a core function of political risk management. This passive approach does not address the underlying risks and can lead to missed opportunities or an inability to effectively manage political risks. It also fails to uphold the professional responsibility to engage constructively and ethically within the established frameworks. Finally, an approach that relies solely on informal understandings or verbal agreements regarding gifts and hospitality, without formal documentation or oversight, is highly problematic. This lack of transparency and accountability makes it impossible to demonstrate compliance with the Bribery Act 2010 requirement for adequate procedures. It also opens the door to misinterpretation, potential conflicts of interest, and the appearance of impropriety, which are all contrary to the ethical standards promoted by CISI. Professional reasoning. Professionals should adopt a proactive and principled approach. This involves understanding the specific regulatory requirements, e.g., Bribery Act 2010, FSMA, CISI Code of Conduct, developing clear internal policies and procedures that align with these requirements, and ensuring comprehensive training for all relevant personnel. Regular review and updates of these policies are crucial to adapt to changing regulatory landscapes and best practices. When faced with situations involving government relations, professionals should always err on the side of caution, prioritize transparency, and seek guidance when in doubt. The decision-making process should be guided by a commitment to integrity, ethical conduct, and robust compliance. Question 8. The risk matrix shows a significant increase in the likelihood of asset seizure due to a newly elected government's platform heavily emphasizing economic nationalism and a desire to regain control over strategic natural resources. Which of the following strategies best aligns with proactive political risk management in this context, considering the potential for nationalization and expropriation? Option A. Cease all operations and divest assets immediately to avoid any potential loss, without further engagement. Option B. Engage in high-level diplomatic discussions with the new government to understand their specific concerns and explore collaborative investment models that benefit both parties. Option C. Publicly denounce the government's nationalist policies and seek international sanctions against the host country. Option D. Initiate immediate legal proceedings to reinforce existing investment protection agreements and prepare for asset repatriation. The correct answer is D. Initiate immediate legal proceedings to reinforce existing investment protection agreements and prepare for asset repatriation. Explanation. The risk matrix shows a heightened probability of expropriation for foreign-owned mining assets in a developing nation exhibiting strong tendencies towards economic nationalism. This scenario is professionally challenging because it requires a nuanced understanding of the interplay between political ideology, economic policy, and resource control, moving beyond simplistic assessments of political stability. The firm must not only identify the risk, but also develop a strategic response that aligns with the regulatory framework of the Political Risk Management Professional Exam, which emphasizes adherence to international investment treaties and best practices in managing sovereign risk. The correct approach involves developing a proactive engagement strategy with the host government, focusing on demonstrating the long-term economic benefits of foreign investment, such as job creation, technology transfer, and infrastructure development, while also exploring options for local partnership or phased divestment. This approach is justified by the principles of responsible investment and the need to mitigate political risk through dialogue and mutual benefit, as often encouraged by international investment agreements and the ethical guidelines of professional bodies. It acknowledges the host country's sovereign right to manage its resources while seeking to protect the investor's interests through collaborative means. An incorrect approach would be to solely rely on legal recourse or immediate withdrawal without prior engagement. Legal recourse, while a potential option, is often protracted, costly, and may not fully recover the investment, especially in the face of strong nationalistic sentiment. Immediate withdrawal, without attempting negotiation or understanding the government's specific concerns, can be perceived as confrontational and may forfeit opportunities for a negotiated settlement, potentially leading to a complete loss of assets and reputational damage. Another incorrect approach would be to ignore the evolving political climate and continue operations as usual, assuming existing agreements will be honored. This demonstrates a failure to adapt to changing political ideologies and economic nationalism, directly contradicting the proactive risk management expected in this field and potentially violating due diligence requirements. Professionals should employ a decision-making framework that begins with a thorough assessment of the political and economic drivers of expropriation risk, considering the specific manifestations of political ideology, economic nationalism, and resource nationalism in the target country. This should be followed by an evaluation of potential mitigation strategies, prioritizing those that foster constructive dialogue and mutual understanding with the host government. The framework should also include contingency planning for various outcomes, including the possibility of expropriation, and ensure that all actions are consistent with the firm's ethical obligations and the relevant international legal and regulatory frameworks governing foreign investment. Question 9. The assessment process reveals that a UK-based company is seeking to secure a significant infrastructure contract in a developing country. The company is relying on a local agent who has a strong network and has facilitated introductions to key government officials. However, the agent has requested an unusually high commission, and their business practices are not well documented. The company's internal legal team has raised concerns about potential bribery risks. What is the most appropriate course of action to manage this political risk in compliance with UK anti-corruption laws? Option A. Proceed with the contract after obtaining written assurances from the agent that they will comply with all applicable anti-corruption laws and that no part of their commission will be used for illicit purposes. Option B. Engage an independent firm of international lawyers with expertise in anti-corruption compliance to conduct thorough due diligence on the agent and the transaction, and to advise on contractual safeguards, while also verifying the agent's existing client list for references. Option C. Instruct the company's internal legal department to conduct a swift review of the agent's background and to approve the contract if no immediate red flags are apparent, given the urgency of securing the deal. Option D. Accept the agent's commission request and proceed with the contract, assuming that such practices are common in the target country and that the company will not be held liable if the agent acts improperly. The correct answer is A. Proceed with the contract after obtaining written assurances from the agent that they will comply with all applicable anti-corruption laws and that no part of their commission will be used for illicit purposes. Explanation. This scenario presents a professional challenge due to the inherent conflict between a company's desire to secure a significant contract and the strict legal and ethical obligations to prevent bribery and corruption. Navigating this requires a deep understanding of the relevant anti-corruption framework, specifically the UK Bribery Act 2010, which is the governing legislation for this exam. The pressure to close a deal can create a temptation to overlook or downplay potential risks, making robust due diligence and adherence to established procedures paramount. The correct approach involves a thorough and documented due diligence process on the foreign agent, including verification of their reputation, business practices, and any potential conflicts of interest. This aligns directly with the proactive measures mandated by the UK Bribery Act 2010, particularly Section 7, which requires commercial organizations to have adequate procedures in place to prevent bribery. Engaging an independent legal expert to review the agent's compliance with local anti-corruption laws and to advise on the contractual terms further strengthens the company's defense against allegations of bribery. This approach demonstrates a commitment to ethical conduct and regulatory compliance, mitigating the risk of prosecution and reputational damage. An incorrect approach would be to proceed with the contract based on the agent's assurances alone, without independent verification. This fails to meet the adequate procedures requirement of the UK Bribery Act 2010, as it relies on self-serving statements rather than objective evidence. It also ignores the red flags raised by the agent's request for an unusually high commission, which could be indicative of a facilitation payment or bribe. Another incorrect approach would be to instruct the internal legal team to conduct the due diligence without engaging external expertise. While internal legal teams are valuable, the complexity of foreign jurisdictions and anti-corruption laws may necessitate the specialized knowledge of external counsel. This could lead to an incomplete or superficial review, failing to identify critical risks. Furthermore, relying solely on the agent's existing client list for verification is insufficient. This approach does not independently assess the agent's integrity or their methods of securing business, leaving the company vulnerable to associating with individuals or entities engaged in corrupt practices. The professional decision-making process for similar situations should involve a risk-based approach. First, identify potential corruption risks associated with the transaction, the counterparty, and the jurisdiction. Second, implement proportionate controls and due diligence measures to mitigate these risks. Third, document all steps taken and decisions made. Finally, seek expert advice when dealing with complex or high-risk situations, ensuring that all actions are aligned with the company's anti-corruption policies and the relevant legal framework, such as the UK Bribery Act 2010. Question 10. Strategic planning requires a political risk manager to accurately assess and respond to various forms of civil unrest. Considering the UK regulatory framework and CISI guidelines, which of the following approaches best reflects the appropriate management of a situation where a large, peaceful demonstration is occurring in proximity to a company's key operational facility, and there is intelligence suggesting a small, separate group may attempt to incite violence and vandalism, potentially escalating the situation into a riot? Option A. Focus solely on the peaceful nature of the primary demonstration, assuming the intelligence about potential escalation is unsubstantiated and not requiring any proactive security adjustments. Option B. Differentiate between the peaceful demonstration and the potential for a riot, implementing targeted security measures to protect the facility and personnel from the specific threat of unlawful activity, while respecting the rights of peaceful protesters. Option C. Immediately implement enhanced security protocols and evacuate non-essential personnel, treating the entire event as a potential riot due to the proximity of the demonstration and the intelligence of potential escalation. Option D. Advise the company to temporarily suspend all operations and close the facility until the demonstration and any potential unrest have completely subsided, regardless of the direct impact on operations. The correct answer is C. Immediately implement enhanced security protocols and evacuate non-essential personnel, treating the entire event as a potential riot due to the proximity of the demonstration and the intelligence of potential escalation. Explanation. This scenario presents a professionally challenging situation because it requires a political risk manager to not only understand the theoretical distinctions between various forms of civil unrest, but also to apply this understanding within the strict confines of the political risk management professional exam's specified regulatory framework, which we will assume for this question is the UK regulatory environment and CISI guidelines. The challenge lies in accurately identifying the most appropriate regulatory response based on the nuanced nature of the civil unrest, ensuring that the proposed actions align with legal obligations and ethical standards for managing political risk in the UK. Careful judgment is required to differentiate between actions that are merely disruptive and those that escalate to a level necessitating specific regulatory reporting or intervention. The correct approach involves a thorough understanding of how UK legislation and CISI guidelines define and address protests, demonstrations, and riots. It necessitates recognizing that while protests and demonstrations are generally protected forms of expression, riots, by definition, involve unlawful violence and destruction of property. Therefore, a political risk manager's response must be calibrated to the severity and legality of the event. The correct approach, by focusing on the legal definition of a riot and its implications for business continuity and security protocols, aligns with the regulatory expectation to identify and mitigate risks arising from unlawful activities. This demonstrates adherence to the principle of acting within legal boundaries and prioritizing the safety of assets and personnel when faced with escalating civil disorder. An incorrect approach that focuses solely on the disruption caused by any form of public gathering without distinguishing between lawful protest and unlawful riot, fails to meet regulatory expectations. This approach might lead to an overreaction or misallocation of resources, potentially infringing on the rights of peaceful protesters. It also overlooks the specific legal thresholds that define a riot, which trigger different levels of concern and require distinct management strategies under UK law and CICI guidelines. Another incorrect approach that suggests treating all public gatherings as potential security threats requiring immediate, forceful intervention is ethically and legally unsound. This disregards the fundamental right to peaceful assembly and protest, which is a cornerstone of democratic societies and is protected under UK law. Such an approach could lead to unnecessary escalation, damage to community relations, and potential legal repercussions for the organization. A further incorrect approach that advocates for ignoring the event until it directly impacts business operations fails to meet the proactive risk management standards expected under UK regulations and CICI guidelines. Political risk management requires anticipating and assessing potential threats, not merely reacting to them. This passive stance leaves the organization vulnerable to unforeseen consequences and demonstrates a lack of due diligence in identifying and mitigating political risks. The professional decision-making process for similar situations should involve a tiered assessment of civil unrest. First, gather accurate intelligence to determine the nature, scale, and legality of the event. Second, consult relevant UK legislation, e.g., Public Order Act 1986, and CICI guidelines to understand the legal definitions and implications of different types of civil unrest. Third, assess the potential impact on business operations, personnel, and assets. Fourth, develop a response plan that is proportionate to the assessed risk, legally compliant and ethically sound, prioritizing de-escalation and safety where possible, and appropriate security measures when unlawful activity is confirmed. Question 11. The monitoring system demonstrates a pattern of increasing government intervention in the energy sector of a target country, including the imposition of new operational regulations and the temporary suspension of certain exploration licenses. The client, a foreign investor in this sector, is concerned about the potential for outright expropriation. Based on the regulatory framework for political risk management professionals, which of the following actions is the most appropriate initial response? Option A. Recommend the client initiate immediate legal proceedings against the host government for potential human rights violations related to property rights. Option B. Immediately advise the client to liquidate all assets in the country due to the high probability of expropriation. Option C. Conduct a detailed, fact-based assessment of the government's actions against the specific definitions and criteria for expropriation within the relevant regulatory framework, while simultaneously gathering information on any compensation mechanisms or dispute resolution processes available. Option D. Advise the client to engage in public relations campaigns to pressure the government to reverse its policies, without first understanding the legal implications. The correct answer is B. Immediately advise the client to liquidate all assets in the country due to the high probability of expropriation. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of expropriation risk within the specific regulatory framework governing political risk management professionals. The core difficulty lies in distinguishing between legitimate government actions and those that constitute expropriation, and then determining the appropriate response based on the political risk management professional's ethical and regulatory obligations. The professional must balance the need to protect client assets with the understanding that governments have sovereign rights, while strictly adhering to the prescribed regulatory guidelines for the exam. The correct approach involves a thorough, evidence-based assessment of the government's actions against the defined criteria for expropriation within the relevant regulatory framework. This means meticulously gathering information on the nature of the seizure, the presence or absence of due process, and any compensation offered, comparing these facts against the specific definitions and thresholds outlined in the political risk management professional's regulatory guidelines. The justification for this approach lies in its adherence to the principle of regulatory compliance and professional due diligence. By following established protocols and definition, the professional ensures that their assessment is objective, defensible, and aligned with the standards expected by regulatory bodies. This meticulous process minimizes the risk of mischaracterization, which could lead to inappropriate client advice or regulatory breaches. An incorrect approach would be to immediately classify any government seizure of private property as expropriation without a detailed analysis. This fails to acknowledge that governments may have legitimate reasons for intervention, such as national security, public health, or eminent domain, which may not constitute expropriation under the regulatory definition. Another incorrect approach would be to rely on anecdotal evidence or general perceptions of government instability rather than concrete, verifiable facts. This bypasses the requirement for rigorous due diligence and objective assessment, potentially leading to alarmist or unfounded conclusions. A further failure would be to recommend immediate divestment or aggressive legal action without first exhausting all avenues for clarification and negotiation, or without considering the specific provisions for compensation or dispute resolution outlined in the regulatory framework. Such actions could be premature, counterproductive, and violate the professional's duty to provide measured and informed advice. Professional decision-making in similar situations requires a structured, evidence-driven process. This involves 1. Actively monitoring political and economic developments in relevant jurisdictions. 2. Establishing clear triggers and thresholds for escalating concern based on predefined risk indicators. 3. Conducting in-depth, jurisdiction-specific research to understand the legal and regulatory landscape concerning property rights and government intervention. 4. Gathering and verifying factual information about any government action that could be construed as expropriation. 5. Applying the definitions and criteria provided by the political risk management professionals' regulatory framework to assess whether expropriation has occurred. 6. Consulting with legal and local experts when necessary. 7. Developing a range of response options, from diplomatic engagement to strategic divestment, based on the assessment and client objectives, always within the bounds of regulatory compliance and ethical conduct. Question 12. The performance metrics show a stable debt-to-GDP ratio for the nation of Eldoria, yet there are increasing signs of public discontent and a weakening of independent judicial oversight. From a political risk management perspective, which approach best evaluates Eldoria's debt sustainability, considering the stakeholder perspective and the potential for political factors to impact repayment capacity? Option A. Prioritize the opinions of foreign investors regarding Eldoria's creditworthiness, as they represent significant creditors. Option B. Focus on the historical trend of the debt-to-GDP ratio and current interest rate projections, assuming political stability will be maintained. Option C. Conduct a comprehensive analysis of the Eldorian political landscape, including the stability of the ruling party, the influence of opposition groups, the effectiveness of fiscal policy implementation, and the potential for social unrest, alongside the debt metrics. Option D. Rely on the assurances provided by the Eldorian Ministry of Finance regarding their commitment to fiscal discipline and debt repayment. The correct answer is B. Focus on the historical trend of the debt-to-GDP ratio and current interest rate projections, assuming political stability will be maintained. Explanation. This scenario is professionally challenging because it requires a political risk manager to interpret complex financial indicators through the lens of political stability and governmental capacity, specifically concerning debt repayment. The challenge lies in moving beyond purely quantitative analysis to understand the qualitative political factors that underpin a government's ability to service its debt. A nuanced understanding of the political landscape, institutional strength, and potential for policy shifts is crucial, as these can significantly impact a nation's financial health, even when raw financial data appear stable. The correct approach involves a comprehensive assessment of a government's debt sustainability by considering a wide range of political and economic factors that influence its capacity to repay. This includes evaluating the stability of the political regime, the effectiveness of governance institutions, the rule of law, the potential for social unrest, and the government's commitment to sound fiscal policies. This approach aligns with the principles of responsible political risk management, which mandates a holistic view that integrates political realities with financial assessments. For example, under the framework of the Political Risk Management Professional Exam, which emphasizes understanding the interplay between political events and financial outcomes, a thorough stakeholder perspective is essential. This means considering not just the government's stated intentions, but also the influence of opposition parties, civil society, international creditors, and the general populace on debt management decisions and repayment capacity. An incorrect approach that focuses solely on historical debt-to-GDP ratios without considering the political context fails to acknowledge the dynamic nature of political risk. This approach is ethically deficient because it provides an incomplete and potentially misleading assessment, which could lead to poor investment or policy decisions. It ignores the regulatory expectation for political risk professionals to identify and assess all material risks, including those stemming from political instability or weak governance, which can directly impair debt repayment. Another incorrect approach that prioritizes short-term economic forecasts over long-term political stability overlooks the fundamental drivers of sustained debt repayment. Political instability, corruption, or a lack of institutional capacity can quickly derail even the most optimistic economic projections. This approach is professionally unsound, as it neglects the core mandate of political risk management to anticipate and mitigate risks arising from the political environment. A third incorrect approach that relies exclusively on the opinions of a few influential political figures, without broader stakeholder analysis or institutional assessment, is also flawed. This is a superficial evaluation that can be easily swayed by individual agendas or short-term political maneuvering, rather than reflecting the underlying systemic capacity for debt repayment. It fails to meet the professional standard of due diligence required in assessing sovereign creditworthiness. The professional decision-making process for similar situations should involve a structured, multifaceted approach. This begins with identifying all relevant stakeholders and their potential influence on debt sustainability. It then requires gathering both quantitative financial data and qualitative political intelligence. This intelligence should be analyzed to understand the political environment, institutional strength, policy credibility, and potential for exogenous shocks. Finally, the integrated analysis should inform a comprehensive risk assessment that considers the likelihood and impact of various political scenarios on the government's ability to meet its debt obligations, ensuring that all assessments are grounded in the specific regulatory and ethical expectations of the political risk management professional designation. Question 13. Compliance review shows that a sovereign debt crisis is unfolding in a key emerging market, driven by a combination of persistent fiscal deficits, political infighting hindering necessary reforms, and a sudden global commodity price shock. As a political risk manager advising international investors, you have identified several potential client responses. Which of the following represents the most ethically and regulatorily sound approach to advising your clients in this situation? Option A. Recommend speculative short-selling strategies based on your assessment of the crisis, encouraging clients to take on significant leverage to maximize potential profits from the anticipated market decline. Option B. Provide clients with a detailed, objective analysis of the macroeconomic imbalances, political instability, and external shocks contributing to the crisis, outlining the potential range of outcomes and their implications for their investments, while emphasizing the inherent uncertainties. Option C. Reassure clients that the situation is likely to resolve favorably and that any market downturn is temporary, focusing on the long-term growth potential of the region to mitigate immediate concerns. Option D. Advise clients to immediately divest all holdings in the affected market, leveraging the perceived urgency of the situation to encourage rapid transactions that could benefit your firm through increased trading volume. The correct answer is B. Provide clients with a detailed, objective analysis of the macroeconomic imbalances, political instability, and external shocks contributing to the crisis, outlining the potential range of outcomes and their implications for their investments, while emphasizing the inherent uncertainties. Explanation. This scenario presents a professional challenge because it requires balancing the fiduciary duty to clients with the obligation to act with integrity and due diligence in a complex political and economic environment. The political risk manager must navigate the potential for significant client losses due to sovereign debt crises, which are often triggered by a confluence of macroeconomic imbalances, political instability, and external shocks. The challenge lies in accurately assessing these interconnected risks and communicating them transparently and ethically to clients, without creating undue panic or making speculative recommendations that could be construed as market manipulation or a breach of professional conduct. The manager must adhere strictly to the regulatory framework governing financial advice and risk management, ensuring all actions are grounded in sound analysis and ethical principles. The correct approach involves a comprehensive and objective assessment of the sovereign debt crisis's causes and potential impacts, followed by clear, unbiased communication to clients. This approach aligns with the core principles of professional conduct, emphasizing transparency, due diligence, and acting in the best interests of the client. Specifically, it adheres to regulatory requirements for providing accurate and timely information, avoiding misleading statements, and ensuring that any advice is based on a thorough understanding of the underlying risks. This upholds the duty of care owed to clients and maintains the integrity of the financial advisory profession. An incorrect approach that focuses solely on short-term gains by exploiting perceived market volatility would be ethically and regulatorily unsound. Such an approach could be seen as market manipulation or insider trading if it involves acting on non-public information or attempting to influence market prices for personal or client benefit, violating principles of fair dealing and market integrity. Another incorrect approach that involves downplaying the severity of the risks to avoid client anxiety without a proper basis for such reassurance would constitute a failure of due diligence and a breach of the duty to inform. This misrepresentation of risk can lead to clients making ill-informed decisions, exposing them to unforeseen losses and violating the ethical obligation to provide accurate and complete information. A third incorrect approach that involves making definitive predictions about the crisis's resolution or specific market movements without sufficient evidence or acknowledging the inherent uncertainties would be speculative and unprofessional. This overconfidence in forecasting future events, especially in the context of complex political and economic factors, can lead to clients making decisions based on flawed assumptions, thereby breaching the duty to provide sound, evidence-based advice. The professional decision-making process for similar situations should involve a structured risk assessment framework, rigorous data analysis, and a commitment to ethical communication. Professionals must first identify and evaluate all relevant macroeconomic, political, and external factors contributing to the sovereign debt crisis. This assessment should be objective and avoid personal biases. Second, they must consider the potential impact of these risks on client portfolios, quantifying where possible and qualifying where not. Third, communication with clients must be clear, concise, and transparent, outlining the identified risks, their potential implications, and the range of possible outcomes, without making guarantees or definitive predictions. Finally, professionals must ensure all actions and communications comply with relevant regulatory codes of conduct and ethical standards, prioritizing client interests and market integrity. Question 14. Process analysis reveals a significant cyber intrusion has compromised a critical data repository. The immediate pressure is to restore full system functionality to minimize operational disruption. Which of the following approaches best balances the need for rapid recovery with the imperative to protect sensitive data and comply with regulatory obligations? Option A. Rely solely on the third-party IT service provider to manage the entire recovery process, including security remediation, without internal validation. Option B. Conduct a comprehensive forensic investigation to identify the intrusion vector, assess the full scope of data compromise, and then implement targeted security enhancements before full system restoration. Option C. Prioritize restoring non-critical systems first to demonstrate progress, while deferring a full assessment of the compromised data repository until after operational stability is achieved. Option D. Immediately restore systems from the most recent backup, bypassing detailed forensic analysis of the intrusion to expedite service resumption. Correct answer is D. Immediately restore systems from the most recent backup, bypassing detailed forensic analysis of the intrusion to expedite service resumption. Explanation. This scenario is professionally challenging because it requires balancing the immediate need for operational continuity with the long-term imperative of robust data protection, all within the specific regulatory landscape of the political risk management professional exam's jurisdiction. The pressure to restore services quickly can lead to shortcuts that compromise security, potentially exposing sensitive data and systems to further or more sophisticated attacks. Careful judgment is required to ensure that the response is both effective in mitigating the current threat and compliant with all applicable regulations. Correct approach involves a systematic, risk-based assessment of the cyber threat, focusing on identifying vulnerabilities, understanding the potential impact of a breach, and prioritizing remediation efforts based on the criticality of affected data and systems. This aligns with the principles of due diligence and prudent risk management expected of professionals in this field. Specifically, it necessitates adherence to regulatory frameworks that mandate data protection, incident response planning, and the implementation of appropriate technical and organizational measures to safeguard information assets. The emphasis is on a measured, informed response that prioritizes security and compliance over expediency. An incorrect approach that prioritizes immediate system restoration without a thorough understanding of the breach's scope and the underlying vulnerabilities would be professionally unacceptable. This failure would likely contravene regulations requiring a comprehensive incident response and data breach notification process, potentially leading to significant legal and reputational damage. Another incorrect approach, such as relying solely on external IT support without internal oversight or validation of their security practices, demonstrates a lack of due diligence and an abdication of responsibility for data protection, which is a direct violation of professional ethical standards and regulatory obligations. A third incorrect approach, neglecting to update security protocols based on the lessons learned from the incident, represents a failure to implement continuous improvement, a core tenet of effective risk management, and a likely breach of regulatory requirements for maintaining adequate security measures. Professional decision-making in such situations should follow a structured process. First, contain and assess the incident thoroughly, understanding its full impact and root cause. Second, develop and implement a remediation plan that addresses both immediate threats and underlying vulnerabilities, ensuring compliance with all relevant regulations. Third, communicate transparently with stakeholders as required by law and ethical guidelines. And finally, review and update security policies and procedures to prevent recurrence, fostering a culture of ongoing security awareness and improvement. Question 15. Quality control measures reveal that a proposed regulatory change by HM Treasury, impacting the reporting requirements for political risk management professionals, is being drafted. The firm believes this change will impose an undue administrative burden without a clear benefit to market integrity. To influence the final policy, the firm is considering several strategies. Which approach best aligns with the principles of effective and ethical policy engagement within the UK regulatory framework? Option A. Prepare a detailed policy paper outlining the firm's concerns, supported by data on the potential administrative costs and lack of demonstrable benefits, and submit it through the official HM Treasury public consultation portal. Option B. Launch a targeted social media campaign highlighting the perceived flaws in the proposed regulation to generate public pressure on policymakers. Option C. Engage a public relations firm to lobby individual members of Parliament, MP, directly through their constituency offices, without disclosing the firm's specific interests. Option D. Arrange for senior executives to have informal lunches with key civil servants involved in drafting the policy to express the firm's reservations. The correct answer is A. Prepare a detailed policy paper outlining the firm's concerns, supported by data on the potential administrative costs and lack of demonstrable benefits, and submit it through the official HM Treasury public consultation portal. Explanation: this scenario is professionally challenging because it requires navigating the complex and often opaque policymaking processes within a specific regulatory framework, likely the UK's financial services sector given the mention of SISI. The challenge lies in identifying and leveraging the correct channels and evidence to influence policy effectively, while adhering to strict ethical and regulatory guidelines that govern lobbying and advocacy. A deep understanding of how policy is formulated, who the key stakeholders are, and what constitutes legitimate influence is paramount. The correct approach involves a systematic and evidence-based engagement with the policymaking process, focusing on providing objective analysis and data to relevant bodies. This aligns with the principles of good governance and regulatory integrity, which emphasize transparency, accountability, and evidence-based decision-making. By engaging through established consultation channels and providing well-researched submissions, professionals demonstrate a commitment to contributing constructively to policy development, rather than seeking to exert undue influence through informal or potentially unethical means. This approach respects the formal structures of policy formulation and implementation, ensuring that any proposed changes are considered on their merits and in the public interest, as mandated by regulatory bodies like the Financial Conduct Authority, FCA, and HM Treasury, and guided by professional standards set by organizations like CISI. An incorrect approach that relies on direct, undisclosed engagement with individual policymakers without a clear, documented process or evidence base is professionally unacceptable. This can lead to perceptions of undue influence or regulatory capture, undermining public trust and the integrity of the policymaking process. Such actions could contravene regulations concerning lobbying transparency and ethical conduct, potentially leading to reputational damage and regulatory sanctions. Another incorrect approach that focuses solely on public relations campaigns without substantive policy input fails to address the core of policy formulation. While public awareness is important, policy decisions are typically driven by detailed analysis, economic impact assessments, and alignment with existing legislative frameworks. Engaging in superficial campaigns without providing concrete, actionable policy recommendations or evidence would be ineffective and unprofessional. A third incorrect approach that involves attempting to influence policy through informal social networks without formal channels or disclosure is also problematic. This bypasses established consultation processes and can create an uneven playing field, disadvantaging those who engage through legitimate means. It also lacks the transparency and accountability required in regulated environments, potentially leading to decisions based on personal relationships rather than objective policy considerations. Professionals should adopt a decision-making framework that prioritizes understanding the specific policymaking lifecycle within the relevant jurisdiction, e.g., UK. This involves identifying key government departments, regulatory bodies, parliamentary committees, and consultation periods. They should then develop a strategy that involves thorough research, data gathering, and the preparation of well-reasoned submissions that address the specific policy objectives and potential impacts. Engagement should be conducted through official channels, maintaining transparency and adhering to any disclosure requirements for lobbying activities. Ethical considerations, such as avoiding conflicts of interest and ensuring all communications are factual and objective, must be at the forefront of all actions. Question 16. The efficiency study reveals that the finance department is increasingly attributing supply chain disruptions and reduced profit margins to economic volatility. However, the underlying cause of these disruptions is the recent imposition of stringent export controls by a key trading partner's government, a direct response to escalating geopolitical tensions. Which approach best distinguishes this situation as a political risk rather than solely an economic or operational one? Option A. Assessing the operational bottlenecks and logistical challenges in sourcing alternative suppliers or rerouting shipments. Option B. Reviewing historical economic data to forecast future market fluctuations and their potential effect on profitability. Option C. Identifying the governmental policy change as the direct trigger for the supply chain disruption and subsequent financial impact, and then evaluating the likelihood and severity of further governmental actions. Option D. Analyzing the impact on the company's balance sheet and cash flow to quantify the financial exposure. The correct answer is D. Analyzing the impact on the company's balance sheet and cash flow to quantify the financial exposure. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of risk categorization, a core competency for a political risk management professional. Misclassifying risks can lead to misallocation of resources, ineffective mitigation strategies, and ultimately, failure to protect the organization from its intended exposures. The pressure to demonstrate efficiency, as implied by the study, can exacerbate this challenge, potentially leading to shortcuts in risk assessment. Careful judgment is required to distinguish the root cause of a potential disruption, ensuring that the correct risk management framework is applied. The correct approach involves accurately identifying the primary driver of the risk. In this case, a sudden imposition of trade sanctions by a foreign government, even if it impacts profitability and operational costs, is fundamentally a political event. The sanctions are a direct consequence of government policy, international relations, or geopolitical shifts, not inherent market forces or internal operational failures. Therefore, classifying this as a political risk allows for the application of specific political risk management tools and strategies, such as diplomatic engagement, scenario planning for geopolitical shifts, and contingency planning for trade disruptions. This aligns with the professional standards of political risk management, which mandate the identification and assessment of risks stemming from governmental actions, political instability, and international relations. An incorrect approach would be to solely categorize the risk based on its immediate financial or operational consequences. For instance, focusing only on the increased cost of goods or the disruption to supply chains without acknowledging the political origin of these issues would be a failure. This misclassification would lead to the application of economic or operational risk management techniques, which, while potentially addressing the symptoms, would not tackle the root cause. This is professionally unacceptable because it deviates from the core mandate of political risk management, which is to understand and mitigate risks arising from political factors. Furthermore, it could lead to a false sense of security if the underlying political instability is not adequately addressed. Relying solely on economic forecasting or operational resilience measures without considering the political triggers would be a significant ethical and professional lapse, as it fails to provide a comprehensive and accurate risk profile. The professional decision-making process for similar situations should involve a systematic risk identification and assessment framework. This framework must explicitly differentiate between various risk categories based on their origin and nature. When evaluating a potential threat, professionals should ask, what is the primary cause of this potential disruption? If the answer points to governmental actions, political instability, or international relations, it should be classified as a political risk. This initial classification then dictates the subsequent steps in risk mitigation, monitoring, and reporting, ensuring that the organization is prepared for the specific challenges posed by political events. Question 17. Benchmark analysis indicates that a multinational corporation is considering a significant investment in a country where a new environmental protection bill is progressing through the legislature. The bill, if enacted, could impose substantial compliance costs and operational restrictions on the company's planned manufacturing facility. The political risk manager must advise the executive team on the best course of action. Which of the following approaches best aligns with the regulatory framework and ethical guidelines for political risk management professionals in this jurisdiction? Option A. Focus all efforts on lobbying key legislators to block the bill's passage, leveraging existing industry relationships, and highlighting the potential negative economic impact on the country. Option B. Advise the executive team to indefinitely postpone the investment until the legislative process is fully concluded and all potential impacts are definitively known, regardless of market opportunities. Option C. Initiate a comprehensive engagement strategy with key legislative committees and relevant government ministries to understand the bill's intent, potential amendments, and implementation timelines, while simultaneously developing internal compliance strategies and contingency plans for various enactment scenarios. Option D. Explore opportunities to interpret existing, less stringent regulations in a manner that would allow the company to proceed with the investment without significant modifications, assuming the new bill is unlikely to be strictly enforced in the short term. The correct answer is C. Initiate a comprehensive engagement strategy with key legislative committees and relevant government ministries to understand the bill's intent, potential amendments, and implementation timelines, while simultaneously developing internal compliance strategies and contingency plans for various enactment scenarios. Explanation: this scenario is professionally challenging because it requires a political risk manager to navigate the complex interplay between a company's strategic objectives and the evolving legislative landscape of a foreign jurisdiction. The manager must balance the need for timely investment decisions with the imperative to comply with local laws and ethical considerations, particularly when dealing with potential changes in regulatory oversight. The core challenge lies in accurately assessing the impact of legislative processes on business operations and making informed recommendations that mitigate political risk without jeopardizing competitive advantage or violating regulatory frameworks. The correct approach involves a proactive and systematic engagement with the legislative process, focusing on understanding the intent and potential implications of proposed legislation. This includes conducting thorough due diligence on the legislative drafting process, identifying key stakeholders, and assessing the likelihood of different legislative outcomes. By developing a comprehensive understanding of the political institutions involved the legislature's role in proposing and enacting laws, the executive's influence in policy implementation, and the judiciary's interpretative power, the manager can build a robust risk mitigation strategy. This approach aligns with the principles of responsible corporate citizenship and regulatory compliance, ensuring that the company's actions are both legally sound and ethically defensible within the specified jurisdiction's framework. Adherence to the political risk management professional exams regulatory framework, which emphasizes due diligence, stakeholder engagement, and compliance with local laws, is paramount. An incorrect approach that focuses solely on lobbying efforts without a deep understanding of the legislative process risks being perceived as undue influence or a violation of ethical lobbying regulations. This could lead to reputational damage and potential legal repercussions. Another incorrect approach, which involves delaying investment decisions indefinitely due to legislative uncertainty, fails to meet the company's strategic objectives and may result in missed market opportunities, demonstrating a lack of proactive risk management. Furthermore, an approach that prioritizes short-term gains by circumventing or misinterpreting legislative intent, even if not explicitly illegal, would be ethically unsound and could expose the company to significant future political and legal risks, contravening the spirit of responsible political risk management. Professionals should employ a decision-making framework that begins with a thorough assessment of the political environment, including the specific roles and influences of legislatures, executives, and judiciaries. This should be followed by an analysis of proposed legislative changes, identifying potential impacts, and developing mitigation strategies. Continuous monitoring of the legislative process and engagement with relevant stakeholders, guided by ethical principles and regulatory compliance, are crucial. The framework should also include contingency planning for various legislative outcomes and a clear communication strategy with senior management. Question 18. Risk assessment procedures indicate that the government of country X has recently implemented a significant increase in the corporate tax rate and introduced new import tariffs on key raw materials. Concurrently, there are public statements from government officials indicating a review of foreign direct investment regulations and discussions about a potential long-term shift towards greater nationalization of certain strategic industries. Considering the immediate financial health and operational viability of a substantial foreign direct investment in country X, which of the following approaches best addresses the most pressing political risks? Option A. Focus primarily on the government's stated intention to review foreign direct investment regulations, as this could lead to future restrictions on foreign ownership. Option B. Concentrate on the government's discussions regarding a potential shift towards greater nationalization, as this represents the most extreme long-term risk to asset ownership. Option C. Conduct a broad qualitative assessment of all stated policy intentions without prioritizing immediate financial impacts to maintain a holistic view. Option D. Prioritize the analysis of the immediate financial implications of the increased corporate tax rate and new import tariffs, as these directly impact profitability and operational costs. The correct answer is D. Prioritize the analysis of the immediate financial implications of the increased corporate tax rate and new import tariffs, as these directly impact profitability and operational costs. Explanation. This scenario is professionally challenging because it requires the political risk manager to navigate a complex interplay of government policies that can significantly impact an investment's viability. The challenge lies in discerning which policy shift poses the most immediate and substantial threat, necessitating a nuanced understanding of their interconnectedness and potential cascading effects. Careful judgment is required to prioritize risks and recommend appropriate mitigation strategies, avoiding overreaction or underestimation of potential impacts. The correct approach involves a comprehensive analysis of the government's recent fiscal policy changes, specifically the increased corporate tax rate and the introduction of new import tariffs. This approach is right because it directly addresses the most tangible and immediate financial implications for the investment. The increased corporate tax rate directly reduces profitability, while import tariffs increase the cost of essential inputs, thereby squeezing margins and potentially impacting the competitiveness of the product. This aligns with the core principles of political risk management, which emphasize identifying and quantifying the financial impact of political events. Regulatory frameworks, such as those governing financial reporting and investment analysis, mandate a thorough assessment of factors that materially affect financial performance. An incorrect approach would be to solely focus on the government's stated intention to review foreign direct investment (FDI) regulations. While this policy shift carries potential future risks, it is less immediate and more speculative than the fiscal policy changes. The review process itself does not guarantee a negative outcome, and the impact is not as directly quantifiable in the short term as tax increases or tariffs. This approach fails to prioritize the most pressing financial risks, potentially leading to misallocation of resources for mitigation. It also neglects the immediate impact on the investment's financial health, which is a primary concern for stakeholders. Another incorrect approach would be to concentrate exclusively on the government's pronouncements regarding a potential shift towards greater nationalization of key industries. Similar to the FDI review, this is a forward-looking statement with an uncertain outcome and timeline. While it represents a significant long-term risk, it does not present the immediate financial pressures that the fiscal policy changes do. Focusing solely on this aspect would mean overlooking the current, concrete threats to the investment's profitability and operational efficiency. This approach demonstrates a failure to differentiate between immediate threats and potential future risks, a critical aspect of effective risk prioritization. The professional decision-making process for similar situations should involve a structured risk assessment framework. This begins with identifying all relevant government policies and their potential impacts. Next, each identified risk should be analyzed for its likelihood and potential severity, with a strong emphasis on quantifiable financial impacts. This allows for prioritization, focusing mitigation efforts on the most critical threats. Finally, the manager should consider the interconnectedness of policies, understanding how one change might trigger or exacerbate another. This systematic approach ensures that decisions are based on a thorough and objective evaluation of the political risk landscape. Question 19. Process analysis reveals that a state-sponsored cyber attack has successfully infiltrated a financial institution's core banking system, leading to temporary service disruptions and the exfiltration of a limited dataset of non-sensitive customer information. Which of the following approaches best represents a comprehensive impact assessment for this incident, considering the potential for broader political and economic ramifications? Option A. Evaluate the technical breach's impact on operational continuity, the potential for cascading effects on market confidence and interbank settlements, and the geopolitical implications of the attack's attribution and potential for escalation. Option B. Assess the immediate technical remediation costs and the potential for regulatory fines related to the data breach, while deferring any broader analysis of systemic risks until the immediate crisis is resolved. Option C. Quantify the direct financial loss from system downtime and the cost of data recovery. Then develop a communication plan solely focused on reassuring customers about the security of their sensitive financial data. Option D. Focus on the immediate reputational damage by drafting public statements and engaging with media to control the narrative, assuming the technical and operational aspects are being handled by the IT department. The correct answer is C. Quantify the direct financial loss from system downtime and the cost of data recovery. Then develop a communication plan solely focused on reassuring customers about the security of their sensitive financial data. Explanation. Scenario analysis. This scenario is professionally challenging because state-sponsored cyber attacks represent a complex and evolving threat that blurs the lines between traditional geopolitical conflict and economic disruption. Assessing the impact requires understanding not only the technical vulnerabilities exploited, but also the potential cascading effects on critical infrastructure, financial markets, and public trust. The ambiguity surrounding attribution and the potential for rapid escalation necessitate a nuanced and proactive approach to risk management, moving beyond reactive incident response. Correct approach analysis. The correct approach involves a comprehensive, multifaceted impact assessment that integrates technical, operational, economic, and reputational considerations. This aligns with the principles of robust political risk management, which mandates a holistic view of potential threats. Specifically, it requires evaluating the direct and indirect consequences of a cyber attack on an organization's ability to operate, its financial stability, and its standing with stakeholders. This approach is ethically sound as it prioritizes the protection of assets, continuity of operations, and the safeguarding of client data, thereby fulfilling fiduciary duties. Regulatory frameworks, such as those governing data protection and critical infrastructure resilience, implicitly or explicitly demand such thorough assessments to ensure preparedness and mitigation. Incorrect approach is analysis. An approach that focuses solely on the immediate technical breach without considering the broader operational and economic ramifications is insufficient. This failure stems from a narrow interpretation of impact, neglecting the interconnectedness of systems and the potential for secondary effects that could cripple an organization. Ethically, this oversight could lead to inadequate preparedness and a failure to protect stakeholders from wider disruptions. An approach that prioritizes only reputational damage, while important, overlooks the fundamental operational and financial stability that underpins an organization's ability to function. While public perception is a critical factor, it is often a consequence of more fundamental operational failures. An exclusive focus on reputation risks misallocating resources and failing to address the root causes of vulnerability. An approach that relies solely on historical data from previous cyber incidents, without accounting for the evolving nature of state-sponsored threats and their potential for novel attack vectors, is also flawed. State actors often possess sophisticated capabilities and strategic objectives that may not be reflected in past incident data. This can lead to an underestimation of risk and a false sense of security. Professional reasoning. Professionals should adopt a dynamic and integrated impact assessment framework. This involves establishing clear lines of communication between technical, operational, legal, and strategic teams. Regular threat intelligence gathering, scenario planning, and stress testing of critical systems are essential. The decision-making process should be guided by a risk appetite statement that is regularly reviewed and updated to reflect the current geopolitical and technological landscape. Ethical considerations should be embedded in every stage, ensuring that decisions are made in the best interest of the organization and its stakeholders, with a commitment to transparency and accountability. Question 20. Stakeholder feedback indicates a growing concern regarding the potential for increased political violence in a key emerging market where the firm has significant investments. The feedback highlights recent protests related to economic inequality and a perceived lack of political representation. As a political risk management professional, adhering strictly to the UK regulatory framework and CISI guidelines, which approach best addresses the identification of potential triggers and escalation factors for political violence in this scenario. Option A. Conduct a detailed analysis of the socio-economic grievances, historical patterns of political unrest, and the current political discourse to identify specific events or conditions that could act as triggers, and assess how these might escalate into widespread violence. Option B. Focus solely on monitoring immediate media reports of protests and government responses, assuming that any significant escalation will be clearly signaled by overt actions. Option C. Prioritize assessing the impact of potential violence on short-term financial returns, assuming that economic stability is the primary driver of political stability. Option D. Rely on informal conversations with local business contacts to gauge the general sentiment, without undertaking a systematic review of underlying political and social dynamics. The correct answer is A. Conduct a detailed analysis of the socio-economic grievances, historical patterns of political unrest, and the current political discourse to identify specific events or conditions that could act as triggers, and assess how these might escalate into widespread violence. Explanation. This scenario is professionally challenging because it requires a nuanced understanding of how seemingly disparate events can coalesce into significant political violence, impacting an organization's operations and stakeholders. The challenge lies in moving beyond superficial analysis to identify underlying systemic issues and potential catalysts for escalation, aligning with the political risk management professional's duty to anticipate and mitigate such risks proactively. The requirement to adhere strictly to the UK regulatory framework and CISI guidelines means that any risk assessment must be grounded in principles of due diligence, responsible business conduct, and the specific guidance provided by these bodies on assessing and managing political risks. The correct approach involves a comprehensive analysis that considers the interconnectedness of socio-economic grievances, political instability, and the potential for violence. It necessitates looking at historical precedents, current political discourse, and the socio-economic conditions within the target region to identify potential triggers. This approach aligns with the CISI emphasis on thorough due diligence and the UK's regulatory expectation for firms to manage risks effectively, including those arising from political instability. By identifying potential triggers and escalation factors, professionals can develop more robust mitigation strategies, fulfilling their ethical obligation to protect the organization and its stakeholders from foreseeable harm. An incorrect approach that focuses solely on immediate, overt threats without considering underlying causes fails to meet the standard of professional diligence. This oversight could lead to a misjudgment of the risk landscape, potentially leaving the organization exposed to unexpected and severe consequences. Such a narrow focus would contravene the spirit of regulatory frameworks that expect a forward-looking and comprehensive risk assessment. Another incorrect approach that prioritizes short-term economic gains over a thorough understanding of political dynamics ignores the potential for long-term reputational damage and operational disruption. This approach risks violating the principle of responsible business conduct, which is implicitly and explicitly embedded within UK financial regulations and SISI professional standards. By failing to adequately consider the broader impact of political instability on all stakeholders. A further incorrect approach that relies on anecdotal evidence or superficial news reports without rigorous analysis lacks the depth required for effective political risk management. This can lead to an incomplete or inaccurate assessment, failing to identify critical escalation factors. Professional decision-making in this context requires a structured, evidence-based approach. Professionals should first define the scope of the assessment, then gather information from a variety of credible sources, including expert analysis, historical data, and on-the-ground intelligence. This information should be systematically analyzed to identify potential triggers and escalation factors, considering their likelihood and potential impact. Finally, the findings should inform the development of appropriate mitigation strategies and contingency plans, ensuring alignment with regulatory expectations and ethical responsibilities.